Welcome to Legal Bytes Over Coffee, an ENS podcast where legal insight meets coffee conversation. I'm Priyanka Raj from the ENS TMT team, and every 2 weeks I'm joined by a guest from across our African offices or an industry partner or a client to discuss what's happening at the intersection of tech, regulation, and business. Together, we unpack the stories making headlines, the challenges emerging in practice, and the contractual and governance questions organizations are navigating in an increasingly digital world. So pour yourself a cup and let's get into this week's Legal Bites. On this week's debut episode, I'm joined by a very special guest, Redwan Boda. Redwan is the head of our ENS TMT team for the continent and is also the co-head of our fintech law practice and co-head of our data privacy practice. And I'm so proud to say that all three areas have recently been ranked band one in Chambers and Partners. So I actually moved across to ENS in 2021 specifically because of Redwan and his reputation in TMT. He was known as being lead legal counsel and still is on some of the largest and most complex technology transactions. And in the recent ranking, Redwan was personally rated as well and was referred to by one of his clients as being the godfather of TMT law. Before we get into today's discussion, Redwan, we always start with coffee. So I'm going to ask you how you take yours, and then I'm going to ask you to guess how I take mine. I want to see if you've actually been paying attention to all the times I've taken coffee in the meeting rooms. So how do you take your coffee, Redwan? Do you
I
drink
go
coffee?
through I go through phases. So sometimes with milk and sugar, sometimes with milk and sweetness, sometimes black with sweetness, sometimes black with sugar, sometimes black with no sugar. So all depends on my mood.
I think one,
And
one, one year we even got you like a Starbucks coffee flask because you were like basically there all the time.
yeah,
Was it
Seattle,
Seattle? Yeah,
Seattle,
Seattle.
yes, yes. In our building at the mark, so quite
Yeah.
quite quite handy and quite easy. I actually haven't had a cup of coffee with you in a long, long time in person
Mm.
because of your relocation to the Western Cape. But if I venture to guess, I'd say
Mhm.
you like it sweet with sugar, with milk.
No, I'm sweet enough for one. So I just have my coffee without sugar, just a little bit of milk.
Okay,
You'll know for next time. But I only have like 1 cup of coffee a day now, so I don't go overboard anymore.
that's good. Too much
Yeah,
caffeine is no
too
good
much
for you.
caffeine.
Most of us survive off it.
Okay, everyone. Before we get into the actual, I think, heart of our discussion, I just want to. I think it's a good one to start with. It's just by looking ahead. It is our debut episode. You are a godfather of TMT, so let me ask you. What do you see? What is on your radar for technology and reg this year?
So for this year specifically, I think if you look at analyze trends where companies are actually spending money on technology. So with technology, we like to divorce the hype of technology against what are companies actually spending money on. And in this past few years, cybersecurity has probably been number one. This year, coincided quite curiously, there seems to be a shift of spend towards generative AI at an enterprise level. So we're seeing most CIOs are prioritizing the introduction of generative AI. Not so much other types of AI for now. I think generative AI is probably the biggest area of spend. Cybersecurity still features significantly. And we're also starting to see an uptake in large outsourcing deals and large systems deals, which we haven't seen for many years now. And I think that's a symptom of the economy improving and also companies realizing that sweating old technology is leading to disastrous consequences. So if one looks at how a company is spending money, I think those are probably the three main areas that we're looking for this year. Obviously, there's still the traditional work in data privacy, in day-to-day cloud computing arrangements, and the general things which keep technology lawyers busy. But if I had to prioritize three areas for this year, it would be AI, cybersecurity, and then large-scale systems or outsourced deals.
Yeah, and I'm seeing so much in the news as well about there's just they keeps making it to the news. These companies have been in traditional sectors for a very long time, and then suddenly they're doing a massive new tech deployment, or as you said, like lots of new outsourcing and systems deals. So there's definitely a lot of that we're seeing. Why do you think there's been this kind of shift, I guess, or not shift, but focused energy on things like generative AI?
I think generative AI, at first there was a lot of hype around it and hype around its potential and what it can do and its transformative nature. I think some of that hype is justified. It is making organizations who are successfully procuring and choosing to success or to procure tools which are fit for purpose. Organizations which are training their staff as to how to get the best out of these tools. I think we're seeing they're starting to realize some form of efficiencies in some sectors more so than others. But we're also seeing a lot of disastrous consequences coming from AI and generative AI implementation and deployment. I think one of the first big areas that we're looking at where companies are getting it wrong is choosing the wrong tool, and mainly because of FOMO, fear of missing out. Uh, be- because companies look at what's out there, what are their competitors procuring, and in a rush to simply get into the AI bandwagon, they would go and procure the same type of technology without first testing with their staff what is actually fit for purpose, what will their staff embrace. And the risk of getting it wrong, number one, you've spent a lot of money on tools that really doesn't make sense for your business. Number two, your staff are not going to utilize it. And number three, that in turn results in shadow AI, where staff start using tools which are not sanctioned by a company. So I think that's where we're seeing a big trend happening when it comes to AI and AI implementation. We're also starting to see some companies getting to testing phases or proof of concepts around specific business or use cases within the operations where AI can actually make the operation smarter, run it faster or more efficient. So I think companies, at first it was a lot of hype, but companies are
Mm.
slowly starting to find their feet. I don't think we're there yet. I think there's still a rush to embrace AI without actually having regard to say, is this AI tool right for me, for my business, for my staff? And is it actually making us smarter? And is it actually making us more efficient?
Yeah, and I'm also seeing something really worried. I mean, it's the legal guys in the business that are getting so scared about what's happening across the business with the shadow AI you mentioned being implemented, and I'm also seeing almost anti-AI deployment, or just this kind of fear of people saying, look, we need to almost regulate this as much as possible. Let's have a lot of policies. Let's have a lot of rules against it just to make sure it doesn't happen. Because I'm seeing that other side of it as well, like almost a reaction to AI.
Yes, I mean, initially when tools like ChatGPT started coming to the fore, the knee-jerk reaction of most companies were, we don't understand this, so we're simply going to ban our staff from using it. I think with time and with experience, what has happened is even companies that may have banned certain tools, people can download and access these tools very easily on their mobile phones, so bypass company networks, bypass company security protocols, etc. And people still went ahead and used tools. But where the companies that are getting it right are introducing some form of policy and regulation without going overboard and without overregulating the use of AI and its impact across the organization. Also, I think until a company doesn't answer the question, what are we actually using AI for? It's very difficult to put in place risk mitigants to then be able to enable those business use cases, because the knee-jerk reaction to say, let's just ban this, that has a counter reaction of shadow AI. Other companies are saying, let's regulate it and look at every one of our policies and let's change all of our policies and put in lots of red tape around AI. That
Yeah.
makes you slower, and the more red tape you are, the more slow, and you won't realize all of the efficiencies around AI. So there's a balance to be found, and the companies that we've seen which have successfully implemented AI focus on four key areas. Number one is training and people. So before you even get to embracing AI tools, train your staff around AI, the different types of tools out there, what works, what potentially works, what doesn't. And with that then goes hand in hand things like governance. And governance involves, okay, now that we have trained our people and our people are aware of the general risks, let's move to governance. So how do we want to govern it? Do we want a risk committee that's separate? Do we want to supplement or augment the duties of current risk committees? Do we want to appoint AI champions? There's no one size fit all around governance. But with governance then comes risk assessments. And again, your risk assessments can only be done once you know what you are actually intending to do or use AI for. So the second leg is governance and risk assessments. The third leg is policy implementation. And again, there's no one size fit all approach. Some companies prefer to overregulate and have lots of policies. Other companies, because of the nature of their business, want to be quite lean, don't want too much policies, and may just supplement, for example, an acceptable use policy with one or two paragraphs around AI. So there's no right or wrong answer. It all depends on the organization and what is the purpose around AI deployment. So the third leg is policy. And then the final leg, which most companies are ignoring, is contracting for AI. And contracting for AI is as simple as an employee going onto the internet, looking at the tool, downloading a tool, clicking I accept, and then utilizing that tool for commercial purposes. It may be a free tool, but hidden in the terms and conditions may be a clause which suggests that if you are using the tool for commercial purposes, there's a fee attached to it. So companies down the line will get burned. So even downloading those free tools and freeware, those don't come without risk. And I think if companies need to pay a lot more attention to contracting, if you are utilizing or implementing AI for specific purposes in your business, then all the more reason to have more robust contracts in place. But again, take a step back. What do you intend to use AI for? Are you that company that just wants to benefit from generative AI? Are you a company that, for example, we had one client, a leading financial services company, tell us that they want to replace 80% of their call center staff with chatbots? So are you that company that are moving from one extreme to the other, in which case there's a lot of risk management around it, everything from employee risk, retrenchment risk, risk of implementing new technology. What goes wrong if that technology goes wrong? What's the client impact? What's the client experience? And what are what contracts underpin all of those? So there's different depending on your perception of risk. Your solutions or your governance would then be informed accordingly. But always start off by saying, what is my business case for using AI? Why am I using it? Is it right for my staff? And do proof of concepts as well, because that goes a long way towards assessing whether your staff will embrace a specific tool or not, as opposed to simply going out and procuring something that none of your staff will use. And that, apart from the commercial risk, which I spoke about, that there's also then the risk of shadow AI, which I spoke about.
Yeah, and I think everything you're saying makes a lot of sense. And I think in responding to the trend of AI becoming more entrenched in business and businesses embracing it a lot more, there needs to be this reaction of responsible AI deployment. And that's something we've been preaching for a while.
Absolutely.
Yeah. I wonder what your thoughts are. Do you think we're going to see any draft bills or regulations locally in South Africa or anywhere else on the continent responding to AI the way our our counterparts in other countries are at the moment?
So just this morning, I read a newspaper article, and I've been very close to this topic that the white policy around AI will soon be being published for public comment. Having inside information and inside reading of that specific document, I still think it's very aspirational in nature. It doesn't speak towards any specific type of legislation. I think the governments in the world that, like for example in Europe, where they have regulated AI, one of the first criticisms came from their own development communities to say, you are placing so much red tape on us, it's actually making us less competitive. So governments are thinking of introducing legislation, but I don't think we're going to see a GDPR type exercise where governments will go and copy paste the EU AI Act and paste it into their own laws. I think lots of governments will be doing their populations a disservice and their development communities a disservice if they were to do so, because from the criticisms that we've seen of the EU AI Act, it is starting to stifle development of AI, and it's making AI solutions or the creation of AI solutions less competitive. Even in the absence of AI regulation, I think most commentators seem to miss the point that there is existing laws which already speak to AI and the regulation of AI. I recall going for a talk many years ago in 2018 as part of my work with the United Nations Data Governance and AI Expert Group. the speaker, the late EU Data Privacy Commissioner, mentioned that at that time the thinking was lawyers and government should not concern themselves with trying to regulate AI. They should rather concern themselves with the impact of
Yeah.
AI. And current legal framework should be sufficiently robust to be able to deal with those impacts. And we do see that in a number of instances. For example, where AI has a data privacy impact, we've already got data privacy laws. Where AI has IP issues, there's already an IP legal framework. Where AI has issues related to bias and discrimination. South Africa, for example, has some of the most advanced anti-discrimination laws in the world. So there are laws which do already cover the impact of AI going wrong. But there is a lacuna, there is a gap. And I think it's that gap that government should seek to regulate, as opposed to over-regulating and making their economies or stifling the economic development simply because of over-regulation. But to come back to your question, I think governments will be regulating AI. As to when that happens, probably still quite a while. I think we're still a few years away from that.
Yeah, and I think it's hard trying to regulate a moving target as well, where risk is still being understood and grappled with as well. So it's going to be very interesting to see which way our regulators here and across the continent lean.
Absolutely.
Yeah.
And one of the problems with trying to overregulate technology is that the technology surpasses the pace of regulation, and
Mm.
governments can't keep up simply because of the way legislative processes work. And that probably is one of the deterrents why government should think carefully before they start regulating AI.
It is interesting. I mean, I've sat on a few audits from the information regulator for certain organizations, and the information regulators are really asking organizations questions about their AI usage beyond whether that AI actually relates to personal information. So it's an interesting exercise of their mandate.
Yeah, one may argue it's ultra vires, but I see it's probably well
Yes.
intended
Yeah.
because in the absence of any government authority speaking about it, somebody probably needs to take the moral leadership around it. And if the information regulator wishes to do so, then that's good for them. I think they probably or may be subject to challenges if they're acting ultra
Mm.
vires or outside of their powers. But I mean, I wouldn't fault the information regulator for wanting to do the right things for the South African public.
Yeah, and I think it does make sense. I mean, Poppy and a lot of data protection laws do share that part about how you actually use automated processes to make decisions about data subjects. I get where they're coming from, but it has been interesting to see that as a common agenda item on all of these audits is, how is your organization using AI? But that comes to also another point I wanted to make about the information regulator in 2026. I'm curious to see how they do flex their powers this year, because in previous years we've seen them, being very collaborative with the different industries, whether it's public or private sectors. They've been collaborating with businesses to see what is their compliance baseline looking like. How do they help get those organizations compliant without rushing to a fine or an enforcement notice. But it does seem, especially in the last, I would say, 6 to 12 months, there's definitely been an increased number of audits the regulators doing, without really focusing on any one sector specifically. So I'm curious to see what's going to happen this year from the information regulator. Are we going to see more fines? Are we going to see more enforcement notices? What do you think?
Yeah, so I mean, I do think the information regulator, they took a while to find their feet, but I do think they are adequately capacitated. They've got very knowledgeable and skilled people within their ranks, and they've got a lot of experience by conducting all of these collaborative type audits. I do see more aggressive enforcement taking place in this year and the years to come because I still think the information regulator initially they were finding their feet. I think they're at the point where they're now comfortable with, what their mandate is, what do they need to do, and what do they need to do in order to adequately fulfill their duties imposed on them under Poppy and prior to a degree. And I think because of the fact that they've now been capacitated, they've got the experience. I think you'll start seeing them take a lot more aggressive stance. I know historically, based on the information that we inside, well, sort of inside information, speaking to people within the regulator, I wouldn't call it inside information, it's just collaborative discussions with the regulator. I think initially they were afraid of being taken to court too often. Because of the fact that they were still finding their feet, there was also some funding issues, etc. But I think they're past that point, and I think we will start seeing a lot more aggressive enforcement taking place.
Yeah. All right. So next, Ridwan, I'd like to talk about what's happening in practice, where we can discuss a challenge or a situation we're currently dealing with that could be relevant to our listeners, obviously without divulging any privileged information. But I think it would be interesting to share our real world on the ground experience and bring that into the conversation, looking at some kind of practical insights regarding what we're seeing on the technology regulatory side of things or even contractual issues. I thought from my side, I'd share that I'm working on a regulatory audit by the information regulator for one of our clients. And it's been very interesting to see the engagements from a number of angles. The one is how long it's actually taken. The audit was triggered, I would say, about a year ago. And what's nice to see is the ongoing engagement by the regulator with the client to see, okay, we're wanting to understand this area. Can you give us more information? So they're not rushing to an enforcement notice. There's a period of engagement as they go through the submissions that we made during the audit, the documentation given, and all of that. But what I'm finding is going to make a difference is how the regulator actually interprets the threshold in Poppy for triggering a notification. Because one of the things they're looking at is where the timiest notification was made. Was there a delay in notification? And it all comes down to, when was reasonable awareness established? To trigger access or acquiring of data by an unauthorized person, because that's the threshold in Poppy. And there's been quite a bit of back and forth between us and the regulator on the difference between actual awareness and reasonable awareness, and at which point can it be fair to say, look, we should have known at this point that we were breached. And it also ties in with the obligation to have reasonable and adequate security measures. And I think the reality is, and what we're trying to argue is that the breach can happen, and we've often advised clients you will get breached at one point, in your
Absolutely.
lifetime as a business. But what will turn on is the measures you had in place. Were those reasonable? Were those adequate based on your risk profile as an organization? What the data you process, and that's what this whole investigation is coming down to is, the measures that were in place, were they adequate to trigger reasonable awareness? And it's become so technical. And I think what organizations need to appreciate is that the regulator is, as you say, very well capacitated. They actually have technical experts sitting in their office. So you can't really, try your luck and say, oh well, we didn't have these measures in place because they were, best practice, and we're only aiming for reasonableness.
Yes.
Those people will actually say, listen, for your industry, for the type of data you process, you were expected to have more robust measures in place. So it's, for me, going to be very interesting to see how the regulator comes out with their findings. But yeah, I'm monitoring the space. But how about for you? What are you busy with?
Yeah, so I just comment to that. I think wherever the word reasonable is used, you're always going to have a clash of interpretations.
Yeah.
One of the old English jurists once quote to say, "Reasonableness is in the eye of the beholder." So the
Yeah, we
regulator
don't
may have
like it in
one
our
view.
contracts either.
Yeah, yeah, exactly. The regulator may have a view, we may have a view, and a judge may take a totally different view to both parties. So very interesting matter that you're working on. One of the matters that I recently concluded was a contractual negotiation. And for probably the second time in my career, it was a contract that never got signed. And there were a number of reasons for this and a number of lessons that we took from this negotiation. It was no fault of us as lawyers. There were a number of factors influencing it. But I think for parties to a negotiation, I'll just give some background to the matter and some key takings from it. So we were acting for a certain financial services entity in an engagement with an IT service provider. And the negotiations were typical negotiations, probably 2 months in, thrashed out all the issues. And we were left with about 3 or 4 issues. And we thought that we were pretty close to signature on the matter. It was just a few issues which we were confident as both parties that we would find common ground on. Suddenly, one day, we received an email from our opponent to say, actually, somebody on their board of directors has picked up the draft contract and they are not happy with it, and they are now marking up the contract from scratch again. Needless to say, after spending so much time on the matter, our client was furious. We as a legal team were furious because it really was not the most ethical way in which to behave themselves. But our client thought to themselves, the option is, what do we do? Because we went out to tender, but we only selected one party. We never gave competitive tension in the matter. We only have this party to deal with. And now we have to go back to market. We probably have to start the whole tender process from scratch. That's going to set us back probably a full year. So perhaps let's just try and entertain them as far as possible. So the first lesson in there was always try and keep competitive tension in your bids. And it may be you may think it's a waste of time and effort, but actually it saves you in the long run when things go wrong. So that's just one taking. So as the matter progressed, we then engaged with our counterparty, and needless to say, we were not impressed that they raised issues which, first of all, they never raised in their first markups, and second, they raised issues which we thought we had agreed with them on. And our clients still, again, trying to be too nice to their opponents, and this is where another big issue comes in to IT contracting specifically, is that sometimes I feel technical people and even commercial people are too nice to their opponents, and they become too cozy with their opponents. Sometimes it could imply something as serious as a corrupt relationship. Other times it's just genuine nice guys around the table who don't want to disappoint the person who's sitting across the table because they may be going out for coffee later, or maybe having a dinner later, or they move in the same social circles, whatever it may be. But our client, for whatever reason, said, and we should still entertain the markups, notwithstanding that it's setting back the process. So that's another key taking. Always analyze people in the room, including on your own side, because 20 years in the IT industry has taught me that this is one of the most corrupt industries out there. Corruption does occur, and sometimes it may not be corruption. It could be your negotiating teams are simply not strong enough or equipped enough to be able to enter into a large negotiation. And that's where your preparation is critical as a negotiation team, and your clients appointing the right people to be in the room is critical as a negotiation team. So that's the next taking. So we're moving on with the matter. We finally got to the point where we were making progress. It was slow, it was painful. Tempers were flying on both sides, and then the company, who had they 1 month later simply resolved those 3 issues, signed the contract, would have had a signed binding contract, were then told by our client, actually, we are no longer contracting with you. We are pulling out of this process because there was some allegations against you around corruption, and very public allegations of corruption. So that's another matter for companies that try and prolong legal processes and try and drag it on. When you close to signature, sign the contract. If you are in the business of conducting business, then focus on your business and securing your revenue. Things like liability provisions, etc. If you are behaving yourself, if you are doing everything that you promised in the first place, you shouldn't be too afraid of those. The clients or our counterparty's self-created delay meant that they eventually lost out on the deal altogether. It would have been interesting to see, had we signed the contract and the allegations of corruption, and it was unrelated to the transaction we were working on, but if the allegation of corruption had come out, what our client would have done under those circumstances. But again, that's where, as lawyers, it's essential that we build in protections for our clients when these things happen. We call it colloquially the Gupta clause that we add into our contracts to make sure that when these things happen, that our clients do have some ability to be able to exit an agreement where there are these public allegations. So a really interesting matter, really long protracted contract negotiation. And like I said, probably one of two deals in my entire 20-year history of as a IT lawyer, which actually never got signed. And I think our client in the end were better off not going with this party because of the allegations made. So that's one interesting matter that I recently worked on. We always working on a number of interesting mandates all the time in the contractual space, but another area which I'm focusing a lot on is data monetization. And uh, a lot of times I meet with companies, including technology companies or banks, financial services companies, and I hear people tell me we can't do this because of Poppy. And the second I hear that, I want to cringe. And a lot of it stems from lack of training, lack of understanding, but
Mm,
also bad advice. There's so much. I mean, when Poppy came out, there were so many. There's really credible people who knew what they were doing and who are still credible. And there's also lots of opportunists out there in the market. And, clients looking around shopping for the best possible deal, going for the cheapest option to do their POPI compliance, don't always get the best advice. And that costs their business money in the long term because they would have been able to spot commercial opportunities or undertake commercial opportunities without being told we can't do this because of POPIA. So a big part of my work is in this data monetization space. And I always ask, and I recently, just this week, I met with a client, and my first question to them is, tell me your business case. Tell me what you want to achieve. Forget everything you think you know about the law. Forget everything you think may be an impediment. Tell me in your ideal world, what do you want to create? What do you want to take to market? Who do you want to sell? And which jurisdictions do you want to sell? That's the starting point. Once we understand the business case, we can then further interrogate a lot more detail. So then we'll start understanding, okay, how does this product work? Where is the data coming from? Where have you obtained it from? How is it flowing in, through, and out of your product or your system or your organization? And like that, we could then look to see where potential regulatory stumbling blocks. And to date, we've successfully managed to help virtually every single client who wanted to monetize or commercialize data with their data commercialization or monetization activities, all whilst complying with the legal framework. So behaving and doing so in a responsible way. So that's a big area which I'm working on currently, and I think it's a really interesting area. And we're seeing it gain lots of momentum
yeah.
and lots of scale as well.
And I think to what you just said now on data monetization, our approach is not to tell clients, you can't do it. It's more like, okay, what do you want to do with this with this data or this opportunity? Let's see how it's possible. Because the thing with the
Exactly.
law is there's so many ways to interpret it. I mean, and justify things. And I think organizations are just looking for profits and trying to come up with innovative solutions. So
Yeah.
the legal team should never hinder that.
Exactly. And we don't ever believe as lawyers we are the red tape. We are there
Mm,
to make sure you can take a product to market, not slowing you down with red tape, but take it to market confidently, knowing that if there is a challenge, if there are questions from your customers, you have all the right answers to begin with. And that instills trust in your products. And when you are able to go to a client with confidence to say, this is a product we are taking to market. We are making it available to you. We've had this legally vetted by
mm.
experts from, the largest law firm in Africa. That goes a long way to instilling trust in your product as well. And I think we're seeing an uptake in data monetization work, and it's a really interesting area for me personally, and something I really enjoy doing day to day.
Yeah, and it's a shame that people think it's prohibited. I've never understood the logic behind that. Like to say, oh, you can't monetize data, you can't sell data. I mean that there are ways to make it possible and lawful. So it's very frustrating.
Exactly. So Poppy doesn't inhibit or stop you from doing business. It actually just makes you behave responsibly. And in the end,
Responsibly,
that
yeah.
responsibility actually gives you a competitive edge. So there's a business case for compliance
Yeah.
in that instance. And, again, tell us your business case and we'll make it happen for you.
Yeah. So I want to move over to a segment. I gave you some homework, but it's the clause of choice. I asked my guests to bring a contractual clause they've been thinking about, any issues that you've been experiencing in negotiations or new risks and how to think about it. So what have you brought for us today, Ridwan?
I'll bring something that's very old, very
Mm,
neglected. It's an everyday thing which people sign day in, day out, and that is your old-fashioned NDA, your non-disclosure agreement. So every NDA has this provision which is stuck in 1995 or even maybe 2005, which says if the agreement is terminated or if our relationship comes to an end, you will return our confidential information or destroy it. So in the world where there were paper documents or memory sticks or CD-ROMs, that like kind of thinking, that like kind of clause worked. But in a world where we deal with cloud computing, where data is channeled in real time or accessible in real time, where it sits on multiple servers around the world, that return of confidential information or destroy confidential information does not work, because even destruction of confidential information or of data has legal implications. So if a law, for example, requires you to hold on to that data for a specific period of time, you can't simply delete or destroy that data. There's also different ways to delete data. You can delete it, for example, take a very simple everyday example. You get an email in your inbox, you delete it. It doesn't mean that email is gone. It's just gone to a different folder. It's still on your system. It's still on your servers. So what we are encouraging clients to do, and this is an article which we will be publishing real soon, is your old-fashioned NDA needs to be revisited and brought to 2026, where we deal with different types of technologies, different ways in which people exchange information, and different ways in which people share and make available information, and bring those provisions up to 2026. The old-fashioned return my confidential information or destroy it, that does not work. That may have worked in 1995 or even 2005. It does not work now in 2026.
Yeah, and I think that's important because the risk with just over retention of information, it's so easy to materialize when you have like these really impressive systems that promise indefinite storage or easy retrieval. And you think, I thought I deleted this thing, but it keeps coming back from the dead. So I think
Absolutely.
that's going to be a very interesting article when it does come out, Ridwan. Thanks. So
Thank you.
moving on to one of our last segments, Ridwan, it's the anonymous question segment. So we get someone to submit a question anonymously to us, and we respond to it here on the episode. But they reflect uh, real situations that are happening with our listeners and what they are dealing with, and they're just asking us for our advice. And I know, Ridwan, you always say we don't charge for WhatsApps. So this is basically like the WhatsApp chat. So we get a
Correct.
question, and we tackle it here, and then we also ask people to just continue engaging with us. Ridwan's contact information is all over the internet, so you're very welcome to WhatsApp him, and we'll
Anytime.
also link details as well. But you can also write to us at info@ensafrica.com if you have a question you'd like for us to discuss on the podcast. So today's question, another AI question, Ridwan. We're implementing an AI-enabled solution provided by an international vendor, but the contract says the vendor isn't responsible for decisions made using the system's outputs. But our internal teams will rely on those outputs operationally. How should organizations think about accountability and risk allocation in this situation? I think that's a really good question,
Absolutely.
and one we're seeing in practice quite a lot. So let's unpack it, Ridwan.
Absolutely. So yeah, no, no, not the easiest of questions to answer, but I'll try and get to it. So I think those type of clauses are very commonplace in vendor-friendly contracts, and I think the starting point is if you are going to be signing your vendor contract, don't think that your vendor is fair to you or your counterparty is fair to you. They put their best foot forward in their contract, and it's for you to negotiate. That's just a side point. When we come to dealing with this issue around decision making and using outputs for decision making. I read a very interesting quote the other day which says you can outsource technology, but you can't outsource accountability. So basically, if your teams are relying on AI outputs, and if a regulator or court were to scrutinize it, they'll first look, or they will look at you first if something goes wrong. And the key issue at that point is not what the contract says, but it's who controls what. And this is where, we've got probably four different things that companies or client needs to take into account. Number one, we must always separate legal accountability from commercial risk allocation. So a vendor, as is typical, would often disclaim responsibility for decisions made by output, but that doesn't remove your duty as a customer or as a customer towards a regulator, your governance obligations, or even exposure if harm comes along. Number two, you need to align your risk with control. What this essentially means is that the vendor should ideally stand behind the integrity of their model its design, its training data, performance claims, etc. But if you are the one who's configuring it, embedding it into your workflows, and choose to rely on it, ultimately you are the one who assumes responsibility for how it's used. And then the third, we always encourage clients never accept what we call a black box plus disclaimer. What this basically means is that if you can't test something, if you can't audit it, if you don't understand its limitations, if you can't monitor its performance, then you can't simply rely on your vendor to take accountability. That's a governance failure on your part and not a contracting issue. So I think the ultimate question which every board and every company needs to ask themselves is, if the system causes harm, can we demonstrate that our reliance on it was reasonable? If the answer is yes, because you've negotiated proper protections and embedded real oversight, then you've allocated risk properly. But if the answer is that, sorry, the vendor disclaimed liability, then that won't be enough. So very tricky question, very difficult to negotiate, especially when you are dealing with or off-the-shelf product where you simply click I accept and move on. But utilizing technology does not detract from the fact that you are still accountable for the outcome of that technology. And whether it's AI or any other type of technology for that matter, take something as simple as an email system. Microsoft or whoever your email provider is makes available an email technology to you so you can send and receive emails. The technology is made available to you. It's there for you to use. But if you're using that same email to send defamatory, racist material and start swearing and insulting your colleagues and your friends and the members of the public, then you are accountable. You are still responsible for that output. And you are still responsible for the manner in which you used it. So when it comes to AI, I think the ultimate safeguard for any organization is there must be human in the loop reviews of any output. So if you simply are going to rely on output, take it as it is, not apply your mind to it, not see whether this is correct, not see whether this may have unintended consequences. And a human being would need to do that. Then you are not using AI responsibly and you're not using AI properly. And you can't always rely on disclaimers to get out in that situation, because there still needs to be accountability on you as the customer.
Yeah, absolutely, Ridwan. And I think from my side, what this question brings up for me is two things. The first is how important it is to vet the vendor when you are engaging them for the service at the very beginning, because I think that's when you can also interrogate what their AI principles and policies are. How do they implement a human in the loop with the outputs that they generate, and what your expectations are as a customer when you're engaging this vendor to those outputs and the accuracy in those outputs. And the second piece for me as well is we often see that clause in IT contracts that needs to be scrutinized, especially now in the age of using AI with your vendors, is those exclusions around, we can't guarantee that, you will get any accuracy complete outputs from us or data. And I think those kinds of exclusions really do need to be interrogated, especially if here the listener says that they're relying on the outputs. You need to make sure that those exclusions that you come across in the contract, that you do interrogate them properly. They can be in a warranty clause, they can be in a liability clause, all of
Absolutely.
those ones, yeah, where the vendor will try to say, look, we can't guarantee accuracy of outputs. Yeah.
Absolutely. So there's still a risk before you even procure an AI tool.
Mm,
That's where your risk assessments become important. So at the procurement stage, you already need to start asking the right questions. And
mm,
that's where companies are really getting it wrong. They are not treating AI as, especially utilization of AI as, or with sufficient diligence at the procurement stage. Because upfront, if you ask the right questions around what are you vendor doing around have you conducted, for example, privacy impact assessments, ethical impact assessments? What are you doing to mitigate bias? What are you doing to foster transparency? Does your tool give me transparency? Do I have audit rights? If at that stage you haven't asked the right questions, then you can't wait until the contract stage when you encounter this clause to say, I now want to unpack everything from scratch with you, and because your negotiating power by then is significantly reduced and reduced to quite a large degree. And you may be 3 months into a negotiation encountering this clause, it's going to be very difficult for you to walk away from a specific transaction at that stage. So ask the right questions right up front at the procurement stage, and you'll find things like this and clauses like this become a lot easier. Naturally, it goes without saying that if you're procuring something off the shelf and you're clicking I accept, then you have no negotiating power, in which case you still need to conduct a risk assessment and find other non-contractual measures to mitigate your risk and to protect your organization.
And the best time to ask the vendor questions is always when they're in sale mode, not
Absolutely.
once they've signed the deal and now they're guaranteed of this revenue, and then you're having the contractual conversation. So I do hope in this year, coming back to our earlier conversation about trends, I do hope we see more proactive contracting for these types of risks. All right, thanks,
Absolutely.
everyone. And
Yeah, proactive procurement and proactive contracting. I think
yes,
the two
yes,
go hand in
absolutely.
hand with each other.
Yeah. Yeah, and if you have any questions you'd like for us to discuss in the podcast, just please do write to us at info@ensafrica.com. So, Ridwan, to close things off, I'm going to end with a very quick game. So, some rapid fire views from you on different risks or trends or debates. But my game with you today is called Overhyped or Underestimated. So, I'm going to give you a few rapid fire scenarios, and you have to say if it's overhyped or underestimated. And I know you like to justify your responses, so I'm gonna cap you at just one sentence if you want. Okay.
Okay,
All
I'll
right.
try.
Agentic AI in regulated industries. Overhyped or
Sorry,
underestimated?
underestimated,
Next one is the board's personal liability for cyber failures.
underestimated,
Uh, Data localization requirements in Africa.
underestimated,
Algorithmic bias.
underestimated,
IT project failure.
very underestimated,
Shadow AI.
underestimated,
Due diligence of vendors.
underestimated,
AI replacing professionals.
overhyped at this stage,
Yeah. And the last one is executive sign off on AI deployment.
underestimated.
I think I gave you some easy ones there, Edward.
Yeah, fairly easy ones.
All right, and that's a wrap on today's episode of Legal Bites Over Coffee. Thank you so much, Redwan, for joining me with this conversation and for being part of our debut episode. I'm really excited, and we'll have you again. And just to our listeners, if you found this discussion useful, please join us again as we continue to unpack legal bytes behind Africa's digital economy. And please do follow Redwan. He's very active on LinkedIn. And on his LinkedIn page, you'll find his contact information. So please do reach out. But until next time, we can just keep our coffee warm and the governance questions hot. Thanks, Redwan.
Thank you and congratulations on your first episode.